Jeffrey Clark, remember him? Key player in Donald Trump's scheme to steal the election. He was a Justice Department official at the time. He's best known for this image, which you probably do remember, where he's caught pantsless when FBI agents served a search warrant on his property. But the now indicted accused racketeer has bigger problems on his hand. He's facing 2 felony counts in Georgia for his attempts to steal the election in the state. And in his effort to fight those charges, he's trying to move his case to federal court. His argument is that because he was acting under the color of his DOJ office, the case belongs there in federal court, not in Fulton County Court. And today, a hearing was held in federal court in Atlanta on his motion before the same judge who rejected Mark Meadows' attempt to do the same. But in a surprising twist, Clark did not show. Instead of testifying to bolster his case, like Mark Meadows did last month, remember we were all surprised he did that, Clark didn't take the stand. He instead tried to submit a declaration in writing that the judge rejected. Doesn't really work that way. Clark's team argued that this case belongs in federal court because Trump, quote, ratified his conduct. Danya Perry served as Deputy Chief of the Criminal Division for the U.S. Attorney's Office in the Southern District of New York and as Deputy Attorney General for the state of New York. Lisa Rubin, former litigator and MSNBC legal analyst, they join me now. Again, from my amateur perch, it always seemed to me that all these people, Meadows probably had the strongest claim to remove to federal court based on federal law that says if you're acting under the color of law, you can remove. Clark seems like less of a case. How did it go today in the hearing?
Not well, right? Because the burden in a removal hearing is always on the defendant who wants to take their case from state court to federal court. And Clark, by not showing up and taking the stand himself and then having all the evidence that he tried to proffer rejected, has fallen short of meeting that. Right. You have an evidentiary burden to meet and your evidence is not accepted. That's not going well for you to begin with.
There was this weird thing where he had Edwin Meese, the former Attorney General of the United States under Reagan, like just write a big kind of essay, like op-ed, like his take. It was like an
amicus brief.
Yeah, it was an amicus brief, but it's like an Ed Meese take. Like, it's just a take. He's just a guy. Like, it's who Ed Meese says, like, yeah, he should be removed to federal court, but the judge didn't seem persuaded by that.
No, he didn't. And on the other side of the aisle, you had the prosecution, which did present not only arguments, but evidence, which, again, the burden is not on the prosecution for the purposes of the removal proceedings, but they actually did provide testimony, live testimony and exhibits. And this was from the head of the Civil Rights Division at the Department of Justice, who directly preceded Jeffrey Clark, and who said, in fact, no, this really is not within the business of the Civil Rights Division. In dealing with election interference and voter fraud, that should have gone to the Civil Rights Division or the Criminal Division, but not to us. So both on the merits and on burden, it was not a good day for Jeffrey Clark.
There's this notorious moment that comes through in the January 6th committee hearing when one of the president's lawyers, it's the guy who got the baseball bat behind him, whose name is escaping me at the time.
Eric Hirschman.
Hirschman says something that he's a little down the block tough because he's like talking to January 6 folks. He's like real puffed up about what he did. But he says at one point, because Jeffrey Clark had been like an environmental lawyer in the civil division where they do like civil litigation, he's like, go back to your office, we'll call you when there's an oil spill. Meaning like, you have nothing to do with any of this, which also, to Danya's point, makes this a little tough for him to pull off.
It makes it really tough for him because not only was he outside his subject matter expertise, to Danya's point, but he was told repeatedly by his supervisors at the Department of Justice, namely Rich Donahue and Jeff Rosen, who were the Attorney General and the Deputy Attorney General at the time, we are not sending this letter. The Department of Justice has no business telling the state of Georgia that election improprieties occurred such that they should convene a special session of the legislature. This isn't happening. Ew. And by the way, you're against Department of Justice policy about who can talk to the president and when. Those people don't include you. Stop talking to the president. Right. And he did it anyway.
Just a little color from inside the hearing today. It gives you a sense of how it was going. This is not confirmed by NBC News. This comes from CNN. The hearing ended after about 3 hours with no ruling from the judge, who seemed visibly frustrated and annoyed at times, with his probing questions directed at one of Clark's attorneys, at one point leading Trump attorney Steve Sato, who was in the courtroom, to whisper, "This is not good." It does seem this stuff is not going to work for Clark, and he is going to end up being tried in Georgia. It still is a question of what that timeline will look like, right?
Yeah, I mean, right now we have a splintered trial, at a minimum, at least into 2 tranches. And so
he's not going in the first group.
He's not going in the first one, which is any minute now, right? It's in October. And so, look, this is possibly a delay tactic amongst,
Right.
I'm sure he had other strategic reasons, but a lot of these defendants seem to want to kick the can down the road, Mr. Trump included. And so it, could be any time from October into, whatever.
But you know what today also told me, Chris, is that we're not just looking at potentially 2 groups, we're looking at 3. Why? Because one of the factors on removal are antagonistic defenses. And Jeff Clark raised the prospect of a defense that is entirely antagonistic to Donald Trump, saying
Donald Trump ratified my conduct.
Correct. And Trump, we understand, has been weighing an advice of counsel defense where he will point the finger at all of his lawyers and say, these guys led me to do it. So if everybody's going like this...
You can't try them together.
He didn't only say ratified his conduct. He said pressed him into it.
Right.
So I don't think he's...
Which I think is also accurate on the
but-
facts, as far as we know. I think there was obviously Jeffrey Clark was happy to help with this. I want to just get one more little bit of news in today, which I just love this detail. This is from the documents case, where every bit of revelations, it seems more and more incriminating as just a general rule. This is he had an assistant named Molly Michael. And this is ABC News saying, as described to ABC News, the aide, Molly Michael, told investigators, she was working for Trump, that more than once she received requests or taskings from Trump that were written on the back of note cards, and she later recognized those note cards as sensitive White House materials with visible classification markings used to brief Trump while he was still in office about phone calls with foreign leaders or other international related matters. Michael saying he had classified docs sitting around like scrap paper that he would grab to write a to-do list and hand to her.
Mm-hmm. And that reporting by ABC News also highlights that Molly Michael made sure that those documents got into the hands of the FBI after the Mar-a-Lago search. Molly Michael, Chris, is also a person who either by name or by reference, in the Mar-a-Lago indictment, she's referred to as Trump employee number 2. In the January 6th or election interference indictment, she's referred to as Trump executive assistant. She's clearly spoken at length with investigators. It's never been confirmed whether or not she is a formal cooperator.
Right.
But I think Molly Michael knows quite a bit about both of these cases, and she's one to watch.
Danya Perry, Lisa Rubin, great to have you both here. Thank you. Still to come.